Sometimes I feel like I'm living in a political circus rather than a system of justice, and nowhere is that clearer than in the Ninth Circuit Court of Appeals. People have been calling it the Ninth Circus for years now, and honestly, it's not hard to see why. This is a court that has built a reputation for activism rather than balance, a place where judges seem far more interested in pushing their own agenda than actually applying the Constitution as it's written. And when it comes to the Second Amendment, it's almost laughable, because time after time, this court bends over backwards to find a way to uphold restrictions, even when the Supreme Court has made it crystal clear how the Second Amendment is supposed to be treated. Think about this: the Ninth Circuit has been around since 1891. That's more than 130 years of history, and in all that time, victories for the Second Amendment have been almost non-existent. Occasional panel wins almost always got overturned. That's been the pattern for decades. For over a century, gun owners across the huge territory covered by this circuit — California, Hawaii, Oregon, Washington, Arizona, Nevada, Montana, Idaho, Alaska, even Guam — have been under the thumb of judges who treat the Second Amendment as something optional, something they can rewrite at will. This isn't some minor regional court either. It's the largest circuit in the country, covering about a fifth of the U.S. population, which means its rulings affect tens of millions of people. And almost all those rulings have gone one way against the right to keep and bear arms. That's why the case of Nguyen v. Banta in 2025 hit like a shockwave. For the first time, we saw a Second Amendment victory actually survive inside the Ninth Circuit without being dragged into en banc and overturned. And the issue wasn't exotic or fringe. It was California's one-gun-a-month law, which said that even if you cleared all the background checks and jumped through every hoop, you could only purchase one firearm every 30 days. The state tried to sell it as a measure against trafficking, but in practice it was nothing more than rationing rights. Imagine being told you can only go to church once a month, or publish one article a month, or vote once every 30 days. People would laugh at how unconstitutional that sounded. But when it came to firearms, California thought it was just fine. The three-judge panel didn't buy it. They applied the standard the Supreme Court laid down in Bruin. Does this restriction line up with America's historical tradition of gun regulation? And of course it didn't. There has never been a tradition of telling free citizens they could only buy one gun per month. In the early republic, the concern was making sure people had arms available for defense, not limiting how many they could own. Under Bruin, California's law had no leg to stand on. The panel struck it down. And here's the part that left people stunned: the decision stood. Normally, California would immediately demand en banc review, the Ninth Circuit would grant it, and the win would vanish. But this time, the state never asked. The ruling became the law inside the circuit. For those of us who have watched the Ninth Circuit for years, it was almost surreal to see a panel win for the Second Amendment that actually survived. Now, nobody should fool themselves into thinking this means the Ninth Circuit suddenly became friendly to the Second Amendment. It didn't. This was a procedural fluke, a rare moment where the machinery that usually crushes these victories simply didn't fire. But even a fluke can matter, because it shows what happens when the judges are forced to apply the Constitution honestly. It reminds everyone that California's endless restrictions can be knocked down when they're measured against history and tradition instead of personal politics. And make no mistake, this ruling matters beyond California. Every state in the Ninth Circuit is now on notice that rationing gun purchases has no constitutional foundation. If lawmakers in Oregon or Hawaii or Washington try to copy California's one-gun-a-month scheme, Gavin Newsom is standing in their way. That's why this single case, modest as it may seem, felt so big. After more than a century of losses, seeing the scoreboard finally change even once was enough to shake people awake and prove that the fight is still worth it. After the shock of seeing Nguyen v. Banta actually survive, it didn't take long before reality came crashing back in. Because almost immediately, another major Second Amendment case came along, and the Ninth Circuit fell right back into its old habits. I'm talking about Yukutake v. Lopez, a case out of Hawaii that shows just how determined this court is to block gun rights every chance it gets. Here's the background. Hawaii had laws that made buying and owning a firearm not just complicated, but deliberately frustrating. Once you got a permit to purchase a handgun, it expired in 30 days. If you didn't buy within that short window, you had to start the process over. Permits, paperwork, everything. On top of that, within 5 days of taking possession, you had to physically bring the gun back to the police station for inspection. Think about that. You've passed background checks, you're cleared to own the firearm, and the state still insists you carry it down to the police like a criminal under supervision. A federal district court called these rules unconstitutional, and in March 2025, a three-judge panel at the Ninth Circuit agreed. They ruled that both the 30-day expiration and the mandatory inspection violated the Second Amendment. Under the Bruin standard, states must show a historical tradition for restrictions, and there is none here. There has never been a practice of forcing citizens to march their guns to the police or telling them their right to buy disappears after a month. These laws were modern inventions of control, not part of America's legal tradition. For a moment, it felt like momentum was shifting. Two panel wins back-to-back in Guyana in California and Yucatán in Hawaii looked like progress. But then came the punchline. Unlike in Nguyen, where California stayed quiet, the Ninth Circuit itself stepped in. They voted to take Yucatán en banc. And with that, the familiar pattern snapped back into place. To understand how outrageous this is, you've got to remember how rare en banc review is supposed to be. Fewer than 2% of Ninth Circuit cases ever get reheard by the larger panel of judges. For most litigants, once you win at the panel, you keep that win. But for Second Amendment cases, it's practically guaranteed. The percentage jumps from 2% to what feels like 100. Every single time gun owners win, the court yanks the case up for rehearing and wipes it away. That isn't a neutral procedure. It's biased, plain and simple. And it's not just Yucatán. We've seen this play out before. In Duncan v. Bonta, a panel struck down California's magazine ban. What happened en banc rehearing decision reversed victory gone. In Young v. Hawaii, a panel recognized the right to open carry. What happened en banc rehearing decision reversed right denied. Over and over again, the pattern is the same: win at the panel, lose en banc. That's why Yucatán feels so familiar and so infuriating. The panel did the work, applied the Constitution, followed the Supreme Court's instructions, and got it right. But the larger court couldn't allow it to stand. Hawaii's overreaching laws were protected not by history or tradition, but by the Ninth Circuit's determination to shield them from scrutiny. What this shows is simple: the Ninth Circuit doesn't play fair. They know the rules, they know Bruin, and they know what the Constitution requires. But when the outcome doesn't match their preferences, they twist the procedure until it does. On paper, en banc looks like a neutral legal tool. In practice, it has become the Ninth Circuit's favorite way to bury any Pro-2A decision before it can take root. So, if Nguyen was the rare fluke that slipped through, Yucatán is the reminder that the Ninth Circuit is still alive and well. It proves that unless something changes, every win for gun rights in this circuit will remain temporary, conditional, and disposable. And that's not justice, that's activism wearing judicial robes. If the Yucatán case already felt like déjà vu, what came next was something different. Into that en banc battle stepped an amicus brief filed by the Second Amendment Foundation, the California Rifle and Pistol Association, and the Second Amendment Law Center. Written by attorney Costas Moros, it didn't just argue law in technical terms. It went straight at the Ninth Circuit itself, laying bare more than a century of hostility toward the Second Amendment. It was blunt, sharp, and for once the court was forced to see its own record laid out against it. The brief began by affirming that the panel decision in Yucatán was correct. There is no historical precedent for forcing citizens to return their firearms for inspection or limiting permits to 30 days. Under Bruin, the test is history and tradition, and Hawaii's laws have none. Normally, that would be the end. But because the case involved guns, the Ninth Circuit chose en banc rehearing. The filing made it clear this was not about the strength of the arguments, but about the court's predictable bias whenever the Second Amendment is involved. What made the filing stand out was its tone. It didn't hedge. It accused the Ninth Circuit directly of treating Second Amendment cases differently from all others. En banc rehearing is supposed to be rare, less than 2% of cases. Yet when the Second Amendment is at stake, it happens almost every single time. The message was unmistakable. The court is not applying the same rules fairly. The brief also detailed the cost of this practice. Groups like SAF and CRPA are nonprofits. Every en banc rehearing drains their limited resources, forcing them to fight uphill battles against state governments funded endlessly by taxpayers. For most litigants, a panel victory means closure. For these groups, it only means the start of another round one designed to wear them down. The imbalance discourages new challenges and undermines public trust. When citizens see victories stripped away again and again, faith in the system collapses. The filing then pushed even further. It urged the Ninth Circuit not only to end the rehearing, but also to correct a deeper mistake the standard used in B&L Productions v. Newsom. In that case, the court had fallen back on interest balancing, weighing supposed government benefits against constitutional rights. But the Supreme Court in Bruin made it absolutely clear that test is gone. History and tradition are the only standard. By clinging to interest balancing, the Ninth Circuit wasn't just resisting gun rights, it was resisting the Supreme Court itself. Reading the brief, the frustration was obvious. Moros listed example after example where the Ninth Circuit was reversed by the Supreme Court for ignoring the Second Amendment. Time after time, the higher court had to remind them that constitutional rights are not optional. Yet the pattern kept repeating as though the Ninth Circuit refused to learn. That was why this filing mattered so much. It wasn't only about Yukutake, it was about the credibility of the court itself. For me, the significance is clear. This was the first time the Ninth Circuit was confronted so directly in writing by those who constantly fight in its halls. It was a warning shot: if you keep abusing en banc rehearing to erase victories, the world will know. The Supreme Court might already be used to correcting you, but now even the advocacy groups are documenting the bias for everyone to see. And that's the real takeaway. Yukutake is more than a case about Hawaii's laws. It is a test of whether the Ninth Circuit can rise above its reputation or double down on it. If they reverse again, they confirm everything critics have said. If they let the panel decision stand, it shows maybe, just maybe, they can follow the Constitution instead of their preferences. Either way, the fight doesn't end here. The Second Amendment has survived every obstacle thrown at it, and every time the Ninth Circuit overreaches it only fuels the determination of those who refuse to give up their rights.